So my question is this: this 180 days, is it inclusive of apparent Supreme Court decision, or is it just limited to the Federal High Court that serves as the appeal tribunal? Appeal court that serves as a tribunal. Is it limited to the tribunal, or is it inclusive of anticipated Supreme Court ruling in the matter as well?
No, 180 days for the tribunal or court, 60 days for the appeals. Supreme Court will have 60 days. 60 days. Oh. The Court of Appeal, which sits as tribunal for presidential election petition, is 180 days. Actually, you can read section 285. But for the appeal at the Supreme Court, 60 days from the date the appeal is filed.
Okay. So are you describing 3 stages now instead of 2?
No, there are 2 stages for presidential election petition. At the gubernatorial level, it is 3.
Okay,
that is
I know that.
Governorship, National Assembly. For governorship, it is 3. For National Assembly and House of Assembly, it is 2. It terminates at the Court of Appeal. But for gubernatorial petitions, you have the Governorship Election Tribunal, you have the Court of Appeal, you have the Supreme Court. For the presidential election, you have the Court of Appeal and the Supreme Court.
Okay,
so in other words, the 180 days is a combination of whatever will happen in the tribunal and the Supreme Court.
No. I've already explained that the 180 days is for the Court of Appeal.
Okay.
Yeah, 60 days for the Supreme Court, independent of the 180 days.
Okay, so it's 160 days and potentially another. So
you are looking at 8 months. You are looking at 8 months.
8 months in all. Okay.
It will not last that long. The good thing about this season of election petition is that there's a new provision of the Electoral Act. I'm trying to recall the section that has basically reduced the work of the petitioners. We say that if there are facts that they can establish by documents, you don't need to call witnesses. You don't necessarily have to call many witnesses to do that. Before now, if you want to raise the issue of disenfranchisement, for example, you have voting. You have to call witness pooling unit by pooling unit. It was a monstrosity. Those precedents were like a monstrosity to petitioners because it was impossible to call a witness from polling units all over the country. It was impossible. You can't call thousands of people. How many days do you even have to prove your case? The tribunal sits to 8 p.m. It is a very tedious work. So the time it was almost impossible. The truth of it is that the courts have been asking petitioners to do the impossible, and I have expressed these views different times, both in legal circles and outside, that we need to amend our laws. The West panel will have addressed some of these things. Start with shifting the burden of proof to INEC.
Of course.
Let it be the duty of INEC to prove that
what they did is
they conducted the election in substantial compliance with the law.
Yeah.
They will sit up. If INEC knew that the burden of proof is on them, nobody would have had any debate about not uploading results to IRF because they would have known what the consequence would be. But now, the burden of proof is on the petitioner.
I think it was deliberately done to assist the riggers. This is our constitution is a scam. Thank you.
Thank you so much, Mr. Ekene. Whether the constitution is not a scam or not, is the constitution that we have.
Sorry, let me tell you another hard thing that you will not read on social media. Another difficult thing about election petition, before this provision of the Electoral Act that I just mentioned, I will get the provision. There's what is called the principle of dumping of documents. So you see all these thousands of pages of documents that Peter Obi and Atiku have obtained. They will tender those documents. The court will not act on them. The court will simply say you dump the documents on them. Do you know what they mean? What that means is that they will tell you have not demonstrated that document. So you don't just tender exhibits or documents in the court. You have to demonstrate it. In other words, you have to call people on the stand to speak to the context. That is impossible in an election petition. It is impossible where you have thousands of documents. So the National Assembly, of all the evils, the satanic provisions that they have introduced in the new act, one of the ones they have introduced that is really good is the one that has now said that if it is possible to prove certain facts by documents, you can simply tender those documents implicitly. And then they should be acted upon. I believe that is the meaning that should be given to them. Because before now, you must call witnesses. I'm telling you, you must call witnesses. And it is not possible, it is not achievable. It is not achievable. That is why people keep taunting people go to court. Beyond the issue of lack of confidence in the courts or compromising the courts, part of the confidence that people that are declared have in taunting you to go to court is that they know the legal landmines that you are going to encounter to prove your case. And God have mercy on you, you read allegations that are criminal in nature, like issue of forgery of certificates. That is not an easy mountain to climb. It's not an easy mountain.
Thank you so much, our teacher. So there has been